this remit to consider the application before her. And it became some banter between the lawyer and the judge in open court. And those are some of the things that I believe that when you go for training, you can look into some of this. The temperament at the bench sometimes makes lawyers exchange, for want of a better word. Thank you very much, my lady.
Thank you very much, Honorable Chair. I believe that the JTI would take that into consideration and ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best, and God bless you.
Thank you very much. Honorable Jerry, you have the floor.
Thank you very much, Honorable Chair. Honorable nominee, congratulations on your welcome. Lady, you've been in this practice for 26 years, and you've dealt largely with issues of dissolution of marriages. Lady, family law cases increasingly involve complex constitutional questions regarding gender equality, children's rights, and traditional versus modern family structures. Given your very extensive experience in family law, how do you view the Supreme Court's role in balancing traditional family structures with evolving constitutional principles of gender equality?
Honorable Chair, can the question be clarified?
The question is seeking to know how you intend to use your background as an expert in family law to deal with issues of constitutional matters, especially people are now making more or concentrating their attention on gender equality. How do you marry the two? How are you bringing your rich experience on family law to deal with issues of gender equality?
Thank you, Honorable Chair. When it comes to family law, the principles are applicable equally to men as it does to women. Because when it comes to distribution of marital property, it is not based on gender, even though it may seem so. It may seem so, but the law is not based on gender. Because it says, Article 22 says that assets acquired jointly during marriage are to be distributed equitably. And whether, irrespective of their gender, that is what the provision is. So it is not in any way discriminatory of any gender. That is my answer to the question.
Just a follow-up. Have you handled cases where the man seemed not to have properties, but the woman seemed to have properties, but they had these properties during the currency of the marriage, and then when it came to distribution, there were issues because the man was now requesting that the properties be shared equally?
I do recall that there was a case before me where the man did not have properties, but the woman did. And I gave the man part of the woman's properties. The man did not have properties, but the woman had properties. And the man was entitled to a share in the woman's properties. And that is exactly what I did. Thank you very much.
Thank you very much, Milady. Milady, The Supreme Court frequently addresses cases involving children's welfare that require balancing parental rights, state intervention, and the best interest of the child. Lady, how can the Supreme Court interpret constitutional provisions regarding children's rights when they conflict with this parental authority or cultural practices?
Thank you, Honorable Chair. The law is clear that in every matter affecting children, the welfare of the child is the court's primary consideration. So in all matters affecting children, it is the welfare of the child. That is the primary consideration. So that is what the law says, and that is what is applied in the courts. Thank you, Honorable Chair.
Lady, have you had the occasion of dealing with a matter that the welfare of the child, although very key, the Constitution perhaps also had a position, and therefore you felt a bit conflicted, especially as a mother?
Can I have a clarification of the constitutional conflicts? I'm not too clear on the conflicts. Thank you.
Well, maybe there was a set, like you just gave a response, and then there was the basis for you to proceed to say that, well, the law is the law, and so I need to proceed to give a judgment or make a decision or a determination based on the law. But you also felt that at this point in time, maybe you could have considered the child's welfare more, but it still conflicted with the law, and therefore you proceeded to deal with the matter the way you had to deal with based on the law.
What I said was this, that where a child's welfare is in conflict with a parental authority, you said, then in that case, the child's welfare will be considered. Because in considering the child's welfare, you must find out whether or not what the authority the parent seeks to exercise is in conflict with the rights of the child. And if it is in conflict with the rights of the child, then you need to prioritize the welfare of the child. That was what my explanation was.
Well, I think it's well understood. Lady, this will be my last question. Is how do you envision the Supreme Court's role in developing constitutional standards for ADR, alternative dispute resolution mechanism?
Thank you very much, Honorable Chair. The ADR Act is the standard for resolution of disputes by either mediation or arbitration. And I believe that this is what is enforceable, even in the Supreme Court. If the matter should probably go to the Supreme Court, but not on the merits, because you cannot appeal against an arbitral award, for instance. You can only seek to set it aside on procedural or other grounds, but not on its merits. There's no appeal in respect of that.
Are there any recommendations you would want to make in reference to ADR, the ADR mechanism?
Not immediate. I can't think of any immediately. Yes.
Very well, my lady. I wish you all the best, and congratulations once again.
You're done, Honorable Chair. All right, I will now call on Honorable Lefiamapo. You have the floor, Chief Rep.
Mr. Chairman, thank you very much. My lady JSC soon to be. You're welcome, and congratulations. During our formative years at the bar, you were one of the few lawyers that anytime you step into court, we had to wait to listen to you. And then when you got elevated onto the bench, we had a tough time before you. So you didn't get here by accident. You merited it. And I'm very proud of what you have achieved so far.
Thank you, Honorable Chair.
I have two questions by way of policy. And so I'll zoom straight into the first one. One of the jurisdictions of the Supreme Court, by way of appellate jurisdiction, is to hear matters emanating from the National House of Chiefs when an aggrieved party, after exhausting the procedure there, proceeds to the Supreme Court. Now, in Articles 270, 271, and 273 speaks of the Chieftaincy institution and the National House of Chiefs and the Regional House of Chiefs. Now, in the Constitution, there is a provision for lawyers to assist the judicial committees when they are determining chieftaincy issues. The National House is to be assisted by a lawyer of not less than 10 years. The regional ones, a lawyer of not less than 5 years. We didn't make any such provision for the traditional councils, the judicial committee of the traditional councils, but we borrowed the spirit and letter of the Constitution and inserted it in the Chieftaincy Act. But the arrangement creates a problem because, I'll set the question, it's a background. The matters that eventually will come before you at the Supreme Court emanates from the judicial committees of the traditional councils. And there we ask lawyers of less than a year or not at least 1 year to assist them. So where error occurs, it then travels all the way to you up there. I know it's this house that must make amends. So will you support a proposal that instead of the lawyers assisting, they are made to participate in the proceedings by being part of the panel instead of being made to assist? And because in most cases, I've done, by way of work, we've done some chieftaincy cases, and the traditional councils don't have money to hire lawyers. So it's the chiefs who go on and handle the matters, riddled with errors. It gets to the region. Some too don't have resources to engage lawyers. So it's the national that really have some lawyers assisting, by which time the damage would have been done.
Thank you, Honorable Chair. I believe it's a laudable suggestion and one that I would support. And invariably, it would also reduce the workload at the Supreme Court. Thank you very much, Honorable Chair.
Great. My other concern is in respect of the matters containing Article 153 and 154, the Judicial Council.
Sorry, Leader. Is this a follow-up or is it a new question?
Chair, I was very clear that I have two questions. Yeah. The first one is done. Okay. So the second one is in respect of the Judicial Council, creature of the Constitution.
Go ahead.
If you look at the composition presently, a very key stakeholder in the justice administration and delivery channel is not included, which is the Ghana Prison Service. Again, would you support the proposition that we should have a representation of the Ghana Prison Service as part of the constitutional amendments represented on the Judicial Council?
Thank you very much, Honorable Chair.
Especially in view of your functions, in view of the functions that the Judicial Council performs.
Thank you very much, Honorable Chair. I believe it's a good proposal because it would seem to me that the prison service is an important stakeholder in the administration of justice. Thank you.
Well, Chairman, thank you. Let me once more congratulate you, and we wish you all the best. And we'll look forward to appearing before you in the future.
Thank you very much.
Congratulations.
Thank you.
Thank you very much. It's the turn of Honorable Patricia PJ. You are Deputy Ranking. You are on the floor.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to take this opportunity to congratulate our lady. And I'm actually ceding my time in order for you to live here. I'm ceding my time to the minority leader to go through. Thank you very much.
Thank you, Honorable Chair.
Thank you very much. I will now cede the floor to Osahini.
Who is that?
The ranking member. Thank you.
Thank you, Chairman.
Please go ahead. Please go ahead. Minority
Chairman,
Leader, please go ahead.
I just heard that you are going to call the majority leader after I'm done for re-examination. Then you call him. He, as a leader, is entitled to be here. Call him. The practice and the protocols which he knows is that I'm the last. I'm your ranking. I'm the last to ask. So you, if he wants to ask, let's allow him to ask his questions.
Honorable Ranking Member, at the moment, I am the chairman of this committee, and I'm the last person to speak. So I indicate who speaks next. You are on the floor. Thank you.
All right. At least what you've just said has become part of our records. A good precedent, no problem. You, when I'm done, just call the majority leader to do his re-examination, no problem. Honorable nominee, we did some checks based on your own CV you brought to us. I want you to clarify for the record. Where did you do your national service?
I did my national service after A level at Kangbili JSS, Kangbili Junior Secondary School. Yes. In the Western region. In the Western region.
Very well. My lady, please, in your time after doing your national service, are you issued with a certificate? During those periods, were you being issued with certificates?
I did not get a certificate. I did not get a certificate when I finished. I am sure I could have applied for a certificate, but I did not get a certificate. Yes.
No, but it never
The reason I ask you, in all fairness, is because national security got back to us that they have no such records of you having done your national service at Kangbunli JHS in Western Region. That's why I wanted you to clarify. Because
I did.
Very well.
Yes.
So you may have to furnish us with some other details you have later, not now, just to confirm. All right. Now, what is your age now, please?
I'm 52 years old. 52 years old.
Very well. So what it means is that if the opportunity avails itself, you would have some 18 years to serve on the bench.
That is correct.
My lady,
Yes.
I intend to take your thoughts on Articles 286 and 287 of the Constitution. I would preamble what I'm going to say. With recent decisions of His Excellency the President regarding imposition of salary fines on ministers and appointees who fail to declare their assets. I shall also want to know your mind on the exclusive role of SHRAJ in investigating breaches of asset declaration obligations. That said, as a background, I proceed to ask you, one, in your view, do you think that the president has a constitutional authority to impose sanctions, such as fines on ministers and other appointees who fail to declare their assets? Or, to you, this function is exclusively reserved for SHRAJ under Article 287 of the Constitution?
I believe that the Office of the President has decided to put in place some administrative procedures. And I do not see that there is a conflict with the duties of SHRAJ. Because if a public officer is reported to SHRAJ as having contravened the law on filing of the necessary documents or declaring assets, SHRAJ would also be entitled to take its necessary action. So I do not think that there is a conflict between the two.
My lady, that said, let's stay a bit on what you describe as the administrative decision. So that is at the heart of my question. Are you therefore suggesting that in spite of that constitutional mandate given to SHRAJ to investigate and make appropriate orders or recommendations, sanctions, etc., administratively, the president, in the exercise of his executive functions, can also impose sanctions, fines, as is the case?
Honorable Chair, I would like the question to be repeated.
So, what I'm saying is that the Constitution mandates SHRAJ to take up matters regarding breaches of the Constitution in the manner that I've already given a background to. And I'm giving you an example of asset declaration. Failure to failure to declare your assets. I am referring to the recent administrative directive by the president to sanction those breaches by way of a fine. In that context, I want to pick your thoughts on whether or not administratively His Excellency can usurp such powers to impose administrative fines as part of his executive powers.
Thank you, Honorable Chair. I do not think that it's a usurpation of powers. That is my position.
Very well. But administratively, Chairman, this strategy by the majority that they have their time, when it gets to my time, then I have follow-up. Anyway, I will yield to you. If you, Chairman, would want to allow these things, no problem. Follow up. And you think that you'll be distracting me. I don't have...
Honourable members, I believe everybody must be treated equally, particularly the leaders. There are instances where the minority leader called for a follow-up question, and he's been granted the floor to ask a follow-up question. In all the vetting that we've carried out, the record can bear me out. So if the majority leader wants a follow-up question, I think it is in good faith that we ask him to do a follow-up question. Please, Majority Leader, you have the floor.
Well, this being the first time I'm speaking, let me join colleagues to congratulate my 1 year senior.
Mr. Chairman, let's be careful what we are doing. It's not good for democracy. If it's a follow-up, let me congratulate my 1 year. If it's a follow-up, you should go straight to the chairman. Don't be doing these things. So it may be politically convenient for you, but tomorrow it will hit us as a parliament.
I can just understand the minority leader this afternoon. Because if the person going to ask the follow-up question is now talking to the nominee for the first time, what is wrong?
If he would have the opportunity to ask his own substantive questions. So he's already indicated to the deputy chair that he would take his turn after me. Please, let us not set a bad precedent. This is not the first time we are doing vetting. Let's stop this. You are the majority. You may not want to delve deeper. Allow us to do our work. What is happening is not good, Mr. Chairman. When we talk, it's like we are sharing your power. Let's stop it. It's not good for the country. It's not good for our image as parliament. And I protest. He says he's going to have his 10.
Honourable members, I do not think any rules of the House has been flouted. So I'll proceed to give the floor to the Majority Leader. Majority Leader, you have the floor.
Thank you very much. Let me join some colleagues to congratulate my 1 year senior at the bar on your nomination to the Supreme Court. By way of follow-up question to what he has done, if a president appoints ministers and public officers and directs all of them to file their asset declaration forms with the Auditor General, and then further directs that when they have filed, they should send him the receipt. Because when you file with the Auditor General, they issue you with a receipt. And he further directs that when you file, forward a copy of the receipt to me so that I see that you have actually filed. If you don't send me a copy of the receipt, I will sanction you. If the president sanctions his appointees for not forwarding copies of the receipts to him, how is that, in your opinion, a usurpation of the functions of the Human Rights Commission?
Honourable nominee, you have the floor.
Honourable Chair, it is to me not a usurpation of the functions, and I have said so. Thank you.
Yes, Honourable Minority Leader, you may proceed.
Honourable nominee, now let me be very specific and pick your thoughts. general sanctions imposed by the president against his appointees for some stated misconduct, in my view, may be within his general powers as an executive president. However, my question to you is, would the president be acting within his constitutional powers, having in mind Article 287 of the Constitution, if he imposes salary fines on his appointees for failure to declare their assets, to impose salary fines?
Honorable Chair, as stated, I do not see that the President has usurped his powers. It is an administrative fine or sanction that he has imposed, and I think it is well within his rights.
To impose salary fines, correct? I mean salary fines. That was your general. I'm referring to the salary fines, the imposition of salary fines. That is the one I'm talking about. As for the general issue of not usurping the powers of Shraj, I've understood you, that he has the powers to administratively sanction. But I'm saying specifically on imposition of salary fines. Your thought on that?
The nominee has heard your question and has provided an answer. So,
Mr. Chairman, yes, he's provided. I've heard the nominee on the issue of usurpation, and I'm not litigating that. I am asking whether specifically the power to impose salary fines, do you consider that to be constitutional? That is my specific question.
Honorable Chair, my position remains the same.
Very well, we move on. Now, my lady, how should the court view presidential actions that appear to preempt or substitute investigative and enforcement role constitutionally vested in Shraj under Article 287?
Can the question be clarified?
My lady, by way of clarification, and I would repeat the question and break it down so that I assist with some example to help. And I thank you for always seeking clarification. So the question is, how should the court view presidential actions that appear to preempt or substitute the investigative and enforcement role constitutionally vested in Shraj? So, instances, now you're going to that all-important court, the Supreme Court. A matter comes before you, and on the face of the facts, you realize that there is a preemption, or the presidency or the executive has taken certain decisions that in itself takes away the powers of a constitutional body. As a court, having seen such a situation, what will be the reaction of the court? That is the point I want to know.
Honorable Chair, I believe that these matters will be determined based upon the evidence before the court and the issue placed before the court. So it's very difficult to make a general statement of how the court would react. So it would be dependent on the circumstances of each particular case. Thank you, Honorable Chair.
My lady, will the courts readily and boldly intervene upon clear breaches in such circumstances based on the facts?
If the court should come to a conclusion that there is a clear breach, then I believe and presume that the court would act. If the court should come to that conclusion, then the court would take an action. Yes, Honorable Chair.
Very well. Let's deal with a bit of rule of law and accountability. In your view, what do you think would be the accompanying risk of allowing a certain president to set the punishment for non-declaration of assets, particularly in the absence of an independent investigation or an independent body constituted for that purpose? What do you think are the constitutional risks?
Honorable Minority Leader, is it not the same question that you are coming back to ask? Same question has been asked and answers provided. So for me, it is the same question that you are rephrasing. So you may answer. You may ask another question, please.
Chairman, if you want to find a way to stop this vetting, I will yield to you. Stop what you are doing. The whole country is watching you. Stop what you are doing. Stop what you are doing. If you want us to fold up, I'm not here to debate with you. I'll fold, discharge her, let us go. If that's what you want to achieve, I've seen it all. This drama, but whatever precedent, if not 4 years, 12 years, 20 years, it will come back and haunt this house. No problem. If you were strategically planning that a Supreme Court nominee should not go through this thing, so be it. But this question is not out of order. I am putting a question. Please pay attention to my question. Pay attention to my question. Pay attention to the question I'm asking. I'm not asking the same question. I've done research. I've worked overnight. I left this parliament, my office, at 12 a.m. Go back here at 6. I know what I am asking. I'm not saying the same thing. For the avoidance of doubt, I repeat my question. What are the constitutional risks?
I have a short response to
Please
what
respond.
you have said. The public is not only watching me, it's watching all of us. And the jury will be out there. I cannot be intimidated by you. I'm a man with indomitable spirit. I still rule that a question has been asked. The nominee will not answer this question again. Pose another question.
Honorable nominee, the executive has its executive powers provided for in the Constitution. What, in your view, will amount to situations where risks are created by allowing the executive to overreach its constitutional mandate with administrative directives?
Thank you, Honorable Chair. A determination that the executive has overreached its mandate will be made when the matter comes up before the court. And if the court comes to a determination that the powers have been exercised in contravention of the mandates under the Constitution, the necessary orders would be made. Thank you.
My lady, in your view, if you are confronted with a requirement to use administrative directive of convenience to solve a problem that emanates from a constitutional breach and a requirement for due process to resolve same, what will be your option?
Yes, Honorable Chair. In all cases where it is established that an action is a breach, then it would be important to proceed along constitutional processes. Yes.
Now, let's delve a bit into the nature of asset declaration and obligations thereto. Do you consider the failure of declared asset under Article 286 to be an administrative lapse or a potential breach of the Constitution requiring formal investigation and sanctions through SHRAJ?
Honorable Chair, I believe that SHRAJ has its procedures for determination of sanctions in respect of breaches of declaring assets. So I believe that whatever it deems appropriate, that is the procedure that would be applied. Thank you.
Very well. But do you think that under Article 286, my lady, let's go to Article 286. It's important we delve a bit into this. First of all, have the opportunity to read. I'll give you the opportunity to go through 286. Then, when you're ready, I can ask the relevant question. When you're ready, please raise your head to prompt me, please.
We can proceed, Honorable Chair.
My lady, upon the full reading of 286, what conclusions do you come there to?
The conclusion I come to is that public officers are enjoined to declare their assets. And where there is a demand for same to be produced, it ought to be produced. That is the conclusion.
Very well. So, my lady, you would agree with me that the Constitution does not create a sanction regime for any breaches thereto, correct? You would agree with me on that?
That is correct.
That being the case, I now would want to ask you that such a lapse that you have identified, what would be your suggestion by way of a cure? Do you suggest, are you of the school of thought that holds a view that in the absence of a clear sanction regime, this should be cured through an administrative directive, or it should be through the Constitution itself?
Honorable Chair, as has been stated, that there is no punishment regime, then what it would mean is that there's a lacuna in the law, and that must be addressed. Thank you.
My lady, there's a lacuna in the law, and that must be addressed. I agree with you, but just to avoid ambiguity, that lacuna, would you suggest a constitutional pathway to addressing same, or an executive administrative directive?
I believe the solution would lie in having a comprehensive discussion or deliberation on how to proceed to address this. Thank you.
My Lord, may you expatiate a bit? I'm a bit at a loss, please.
Yes. What I have said is that it would need some deliberation on how this should proceed. For instance, presently, we have the Constitutional Review Committee sitting. So if proposals are made to it on how to proceed, it can compile these proposals for the necessary action to be taken. So that is my position.
Very well. I agree that that is one approach. What about the court itself taking the matter up to provide the guideline? Would you think that option also suffices?
That option can only be considered when the matter is before the court.
Obviously.
And so the matter comes before the court. One cannot say whether it will be a case where constitutional interpretation would address this lacuna. So until the matter comes before the court, a dissemination of that cannot be made.
My lady, I agree with you on those two views you've expressed. And obviously, that lacuna you've identified, it's only through a process brought before you that you can now determine and address that lacuna. And I agree with you. Your option 2, which is also very fair, is the fact that there's currently an ongoing constitutional review processes or hearings that citizens can point some of these as proposals for them. Now, would you also favor an administrative directive unsupported by law and at one's discretion to address this lacuna? Would you support that?
Insofar as there's a lacuna, it would mean that a decision taken is not contrary to the law if it's administrative. And so I would have no opposition or objection to that.
Very well. My lady, let's now land on executive discretion and constitutional enforcement. In your view, what role, if any, should a president play in enforcing asset declaration requirement, and how should that role be limited to ensure constitutional fidelity?
I'm unable to delineate the various roles that the president should play. That is my answer.
Well, sir, I can guide, just for our purpose. For instance, since he's an appointor and has the power under, is it Article 51? Yeah, 51. The appointment, those to appoint subordinates, officers. No, not too nice. There's 158. Yes, 58. 58, yes, 58. He has some general powers. I'm saying that in respect of those general powers, he may, as part of the democratic goodwill, want to exercise some supervisory functions to ensure compliance. Now, having that background in mind, what I want to extract from you is, in the exercise of such powers, how should that role be limited to ensure constitutional fidelity?
Yes, I believe that the president, I'm aware that the president is a member of the executive.
That is so.
Yes, so
the head in that, indeed.
And so under the circumstances, if any action is taken in respect of its executive members, then I have no issue with it. But obviously, he cannot cross over, even though a judge is a public officer, to impose sanctions on the judge because a judge has failed to declare their assets. That's what I would say.
My lady, a bit of clarification. Is it?
There is a follow-up here, which I'm inclined
let me finish this. He can come in after. Chairman, let me finish this. You can come
you can
in
come
after,
in after.
please. Let me finish.
Let me finish.
My lady, a bit of a clarification. Your case is that, and if I heard you correctly, your case is that for his appointees, there cannot be any constitutional limitation placed on the president in terms of how he ensures enforcement. Is that your case? I just want clarity.
That is not the case.
My lady, so what is therefore your proposal regarding how to limit the president's role in terms of ensuring constitutional fidelity in respect of his own appointees when enforcing this asset declaration law?
Well, the only limits I see under the Constitution, since it's the Constitution, is for a CI, setting out guidelines. That is the only way I see a resolution to the problem.
Yes, I recognize Roxanne Nelson.
Chairman, thank you very much. My lady, within the terms of Articles 287, 1 and 2, and 288, and Chairman, with your leave, let me read 287. 1. An allegation that a public officer has contravened or has not complied with a provision of this chapter shall be made to the Commissioner for Human Rights and Administrative Justice. And in the case of the Commissioner of Human Rights and Administrative Justice, to the Chief Justice, who shall, unless the person concerned makes a written admission of the contravention or non-compliance, cause the matter to be investigated. 2. The Commissioner for Human Rights and Administrative Justice, or the Chief Justice as the case may be, may take such action as he considers appropriate in respect of the results of the investigation or the admission. With this provision and the definition of a public officer under 288, does it not clearly suggest that the law already provides for the remedy and that there's no lacuna, as has been suggested?
Thank you very much, Honorable Chair. Even though there is this provision that says to take appropriate action, it is also the case that where a punishment is not specifically provided for a certain act or misconduct, in that case, it would seem as though we ought to be clear by providing some guidelines for what kind of action needs to be taken. So that is what my answer is.
My lady, now, in situations where the president has executed through his administrative powers, has punished an appointee who is in breach, would you consider it as double jeopardy should Shraj also take the same matter up upon being petitioned to investigate, with the end result being another punishment?
Honorable Chair, I believe that as we have stated, there is no usurpation of power, and insofar as there have been sanctions, administrative sanctions, Shraj can also, if it is petitioned, take a look at it. There's no prescribed sanction which Shraj has to impose, and so the decision would depend on what Shraj decides to do. Thank you.
So it won't amount to double jeopardy?
That is the position I have stated.
Lady, I'm only picking your thoughts that if the person has already been punished through executive decision, and then Shraj also been petitioned to look into the matter with the aim of punishment, if you think that both can be done and wouldn't amount to double jeopardy, I mean, I take that for the record. That's fine.
No, Honorable Chair, what I indicated was that even though Straj may investigate same, there is no prescribed punishment which Straj ought to give. So we may decide at the end of the day to take the necessary steps, having due regard to the fact that the persons have already been sanctioned. Yes.
Okay, my lady, can we bring a closure on this matter by agreeing with your earlier position that we must have a CI to regulate and guide and provide for the lacuna on the sanction regime as identified?
I have already said so.
That's just for clarity. That's why I'm saying to bring closure on this. Do you insist on that?
Honourable member, my lady Angzedra, she has already said so. So if you have another question, with all due respect, proceed to ask the question.
My lady, it is true that in your earlier answer, you indicated that a CI perhaps may suffice. In fact, that was your third suggestion by way of solution. You had earlier talked about when the matter comes before the court or a proposal being made to the Constitutional Review Committee, and now you've added that perhaps also a CI may suffice to help. I have asked you about the possibility of double jeopardy. It is not always likely that constitutional bodies may see it in that light, that the person has already been punished and that they should be guided. It is a reason I wanted for emphasis to ask you that do you think to bring a finality to this matter, a CI comprehensive enough to guide becomes the appropriate approach in this respect? That is all I wanted you to emphasize. That's all.
Honourable member, this question has been asked and answered severally. So with all due respect, proceed to ask another question.
My lady, do you think that unilateral imposition of fines on defaulting appointees affect public trust in Straj and the constitutional process for addressing misconduct in such manner?
I do not think so, Honourable Chair.
Reasons? Reasons, my lady.
I do not envisage a situation where an administrative action would lead to loss of trust or confidence in a constitutional body. I do not envisage it. Thank you.
But, my lady, you would agree with me that this democratic enterprise or this Germany of democracy is perception-driven, and at all points where the public perception tilts in a certain manner, it requires decision makers to make amends. You agree with me?
Can I have the question repeated, Honourable Chair?
As a follow-up to your answer, my point is that democracy is driven by perception, public opinion. So don't you think that where the public view on a particular matter is negative, it calls for revisit or rethink in decisions?
Thank you, Honourable Chair. It depends on the basis upon which the decision was taken. That is what would determine whether or not the matter can be revisited, the basis, and whether or not there will be another opportunity for that matter to be revisited. Thank you, Chair.
Thank you. My lady, we are done with the shrug issues. I want to pick your thoughts on the EC, and I'm focusing on the public criticism surrounding the creation of new constituencies, particularly the apparent alignment between new district created by the executive and the subsequent constituency demarcations by the Electoral Commission. I would anchor the questions on Article 47, 45, 46, and 47 of the Constitution. So, first will be to know your views on separation of powers and the constitutional independence. So, question: how should the independence of the Electoral Commission under Article 45 and 46 be protected or interpreted in the face of public perception that it simply mirrors executive decisions on district creation when establishing new constituencies?
Thank you, Honorable Chair. I believe that the independence of the Electoral Commission is guaranteed by law, so I do not see a situation where their independence will be interfered with.
Very well. Now, given the fact that creation of districts is an executive function and the demarcation of constituencies is constitutionally vested in the Electoral Commission, what, in your view, would you consider as the legal and institutional risk when these processes appear tightly aligned in practice? I'm sure you remember the recent situation in the Oti region. Is it Salah? The South. My friend Franklin Kujo. My friend Franklin Kujo has been very passionate about this. Of course, that's where he comes from, and all. With that in mind, if you could express a view on it.
Honorable Chair, I would pray to be excused from answering this question. The reason being that there's a pending matter in the Koforidua Court of Appeal in respect of these matters. Yes.
My lady, specifically, just guide us. The sub judice rule you are triggering, in my view, must be put in context since it is not absolute. So please guide us. Within the context of my question, what aspects of the question juxtaposed against the issues before the Court of Appeal do you think would amount to sub judice? Should you answer? I just want us to clarify that for us.
Thank you, Honorable Chair. Now, the legality of creation of constituencies or districts is necessarily a matter that is an issue in the matter before the court. Thank you.
My lady, I disagree with you, but I won't pursue. Now, may I know your thoughts on the safeguards that should exist to ensure that the Electoral Commission's power to create new constituencies is not intentionally or inadvertently be to advance partisan interests or perhaps entrenched political power. The thrust of my question has to do with how we can safeguard you as a judge. What proposal, what views can you express as part of enhancing and enriching democracy? What view can you express as part of the safeguards?
Thank you, Honorable Chair. I believe that the Electoral Commission is independent, and I do not see any particular proposal that I can make that would add anything to their independence. Thank you.
My lady, in situations where clearly you see that the constituency being created is following a certain pattern just because there is a creation of a new district. In instances like that, do you think that it may require the court's intervention to place a limitation?
Thank you, Honorable Chair. Honorable Chair, I would pray to be excused from answering this question as well. And I'm being very careful because the issue of SAL, creation of new districts, new constituencies, is a matter that is yet to be determined in the Koforidua Court of Appeal. So I'm very careful not to go into matters that are yet to be determined by the court. Thank you, Honorable Chair.
My lady, in the light of recurring criticism that the creation of constituencies follow executive interest too closely and emphasis too closely, do you think that our country's legal framework on districting and constituency creation needs any reform at all?
Thank you, Honorable Chair. I do not have that impression that the creation of districts follow executive interests. I am yet to be to come to that realization, so I'm unable to make any suggestion or comments on this. Thank you, Honorable Chair.
Now, you are aware that our district assembly or the local governance concept is constitutionally non-partisan. Do you think that in view of other jurisdictions like the United Kingdom, the United States, where local governance is part of the partisan democratic system, Ghana should pursue a reform?
I do not believe so, Honorable Chair.
What is your basis for saying that we should remain with what we have and not reform to make them part of the partisan process?
I believe that the non-partisanship of the district assemblies is better for cohesion and development at that level. That is my position.
But my lady, it is also a notorious fact that the political parties sponsor their activists to pursue their interests at the local governor level in district assemblies. With that view generally known out there in mind, would you still maintain that there should be no reforms to reflect this?
Yes, Honorable Chair, I will still maintain so.
Very well, my lady. My lady, I would now want to focus on the contrast between qualification required for Member of Parliament and those required for judges, particularly in the light of the public criticism that MPs are not held to any formal education or professional standard, while judges must meet rigorous legal qualifications. Now, the IEA survey shows, a recent IEA survey shows that 67% of Ghanaians believe MPs should have at least a university degree. How do you reconcile this strong public sentiment with a constitutional silence on educational qualification for MPs, especially when judges face strict legal and professional requirements in their selection?
Thank you very much, Honorable Chair. I believe that the two categories of functions are different. A judge is a professional and ought to be able to apply the law, because you are primarily a judge because you are a lawyer and you have legal knowledge. But there's no such requirement for members of parliament. And I do not think that there is any reason to insist that every member of parliament must have a university degree, because primarily they are representatives of their people. And if their people think that they are competent enough to come to the House and represent them, I think that should be it. Thank you.
Well, what role, my lady, if any, should our courts have, whether direct or imperative, in responding to the public concerns about the standard of political governance in our country?
If the question may be clarified.
What role, if any, should the courts play as part of the governance of the country to, as it were, enrich the political governance? You are here in this country, and I'm sure you follow the public discourse. Sometimes people criticize, people say, oh, governance standards are low, the standard is this, the expectation is quite mixed. As a judge who is going to sit in a court that determines public policy, do you think that the courts the Supreme Court, let me be very specific, the Supreme Court has any role at all to play in the light of this to enhance the political governance of our country?
Thank you, Honorable Chair. The courts have been given the role of adjudication, and I believe that if there are matters that come before the Supreme Court, which also hinge on political governance, and the court has to determine them, the court will determine them accordingly. And if that in any way would enhance governance, I believe that it will be in a good direction.
My lady, are you a registered voter?
I'm a registered voter, yes.
My lady, which constituency did you register?
I registered in the La constituency. I don't know whether it's called La, but yes, it's at the La area, yes.
La Dadikotopon.
I don't know if
that's the full name of the constituency, yes, La Dadikotopon. Yes. Okay, which area, which polling station or center specifically? The area you were trying to describe, the area where you registered. Which area?
It's at La.
La proper. I know, I lived in La. That's why I'm asking. I know La very well. So which area? Is it the trade fair area, La Wireless, or where the South La, Nyaniba Estate area?
No, no, no. It's not. It's within La Proper. Yes, it's within La Proper.
Very well.
Honourable members, I'm inclined to overrule this particular question. What we should do in vetting the judges are governed by law. Which political polling station they cast their vote, I don't think on grounds of relevance is not required.
Lord, grant me patience. Lord, grant me patience.
I'm a registered voter. Which police station?
My lady, you are 52 now, and you would, God willing, if you are approved, when you get approval of this House, possibly through majority decision, you are likely to be on the bench for 18 years. My lady, at the time our Fourth Republic was birthed, would you say that upon attaining age 18, you registered as a voter, or the current registration where you registered Allah was your first?
I registered as a voter. I don't recall when, but this is not my first. Yes.
Very well, my lady. My lady, we have had elections since '92. We have seen two major political parties ruling the country. We've made some strides as a country within the sub-region, and I say this because my job has gotten me roaming the sub-region, and I say with pride that our country is far better in relative terms. As a Ghanaian, can you share with us some of the shortcomings of how we do our politics and views on ways to enhance it, to make it attractive to the citizenry?
Honorable Chair, I don't have any views on that. Thank you.
Very well. My lady, did you pay attention to the data that was put out by the Electoral Commission regarding the 2024 elections, specifically the turnout, region by region? Did you pay attention to those data?
I did not.
My lady, do you pay attention to the current affairs of this country, governance issues, what happens in parliament, what happens in the executive space? Do you pay attention to any of that?
To the best of my ability, yes.
My lady, clarity. Clarity, I didn't hear you.
I said to the best of my ability.
You pay attention?
Yes.
Okay. Now, since you pay attention to the governance at the legislative level, the executive level, let's take it one by one. At the legislative level, how do you see the performance of legislative functions of parliamentarians, since you pay attention to what the legislature does?
I believe that you are doing exactly what you have been mandated to do and voted to do.
Thank you, my lady. My lady, are there ways that you think there can be improvement to enrich democracy? Can you make some few suggestions as a citizen of Ghana?
Thank you, Honorable Chair. I'm unable to make any suggestions concerning that because I am not an integral part of Parliament or the proceedings. So I don't think it will be in my place or proper to be making suggestions based on what I have seen and probably not everything that transpires. Thank you.
Well, my lady, as an observer who wants the good for your country, yes, without prejudice to being an integral part of the system, obviously you cannot be, you are not part of the legislature. But like you know, judges make their pronouncements and people, ordinary citizens, express their view. They may not be right, or they may not be seeing it the way you saw it, but it's their opinion. You say that for the legislature you cannot. Now, you've also been following executive governance. Have you any views to share regarding some shortcomings that you think can be improved upon?
Thank you very much, Honorable Chair. I do not have any views on the executive. Thank you.
My lady, you are aware of institutions of state whose mandates provided for by the Constitution. You've observed them do their work. Have you any particular state institution that, in your view, you can make suggestions for the improvement of their work to enrich governance?
Thank you, Honorable Chair. I can say that, so far as I'm concerned, a lot of the state institutions are doing what they have to do. Some may be constrained by logistical needs, but other than that, I have no further comments.
My lady, as a judge, what are your peculiar challenges as a Court of Appeal judge? What are some of the challenges you face in the discharge of your duties as a judge that you believe call for reform to enable you do your work and do it well, having in mind even those who assist you? I'm referring to the court clerks and the registrar and all those in that value chain.
Thank you, Honorable Chair. As a Court of Appeal judge, we do exactly what we are supposed to do. We deliver our judgments as we should. We do our research as we should. But I believe that if we had legal research assistants or a pool of legal research assistants, that would also enhance efficient and effective justice delivery.
Is technology enhancing justice delivery in our courts at all? And if so, do you have any suggestions as to how the system can be overhauled or improved to meet trends in modern justice delivery as being experienced in other jurisdictions?
Thank you, Honorable Chair. I believe that the e-justice system is going a long way to expedite cases in the courts in which it has been rolled out, and primarily the high courts. And so in the high courts, proceedings, for instance, are typed in real time. In the high courts where the e-justice is rolled out in Accra, so as the judge speaks, as the lawyers speak, proceedings are typed. And the lawyers can access their proceedings speedily to ensure that they write their addresses on time. The judges are also able to access proceedings, and court orders are also expedited. So, I mean, insofar as the e-justice system is concerned, it is helping in efficient justice delivery. And if we are able to roll it out to other courts, I believe it would help. Yes.
My lady, I want to pick your thoughts on some issues. I don't see them as controversial, but it may be controversial. I'm going to focus on intersex persons, those born with both male and female sexual characteristics, and the discrimination they face in Ghana. Particularly, I bring these issues up to look at legal protection, gender identity, public policy, and the duty of the states under Article 17, 15, and 21, as well as 33 of the Constitution, of course, Article 33, dealing generally on enforcement of human rights. Now, my lady, on the recognition and legal identity, I want to know from you, what constitutional or legal protections exist for intersex persons in Ghana, and how should the law respond to their unique identity challenges, particularly in contexts where they are forced to choose one gender or national forms such as passport or school admissions?
Thank you, Honorable Chair. I believe that every child at birth is assigned a sex, and that is what that child uses throughout their adult life. And so insofar as the person is assigned a sex as male or female at birth, I believe that the identification given to that person would prevail. And so in school, the child will be identified by a sex as male or female. And I believe that is what runs through. Thank you.
My lady, upon your careful reading of our Constitution, the 1992 Constitution, do you think that the Constitution has any protection for the dignity and the bodily autonomy of individuals born with both male and female sexual organs, particularly in cases where irreversible gender assignment surgeries are performed at birth without consent?
Thank you, Honorable Chair. The Constitution offers general protection for all persons. And so if, as you have stated, a gender reassignment surgery is performed at birth, then it would mean that that person at birth has a sex and is identifiable and is covered by the Constitution.
Now, my lady, I want to know about some legal remedies or judicial protections, though you have already emphasized that Article 33 provides those general protection of our rights. But such individuals that we are referring to, you're talking about, face some form of discrimination, some form of stigmatization. As a judge, knowing that the Constitution provides this broad spectrum of protection, what would be your position should those who are intersex persons face exclusion, ridicule, or denial of services because of their condition? And how effective are these protections under the current legal framework, in your view, can best be ensured? What views can you express to help safeguard some of these guarantees in the Constitution?
Thank you, Honorable Chair. Now, an intersex person is born as they are, so it is not a choosing. And the Constitution guarantees freedoms for all persons under its reach, that is, in the country. And insofar as I'm concerned, I do not see that the Constitution is discriminatory of intersex persons, because these are persons who do not choose their sex. They are born that way, and they are protected, in my view.
Well, my lady, I will lift my next question from where you ended, that intersex persons are born with it, they don't choose. But we are equally aware that there are some social and institutional marginalizations that exist. We cannot pretend about it. As a judge, sitting in a constitutional court, would you consider some constitutional, legislative, or administrative reforms to ensure their recognition, dignity, and inclusion in national life? Would you look at it?
Thank you, Honorable Chair. I believe they are covered, as I have stated. And so, to my mind, there is no further need to find special legislation for them.
My lady, by way of follow-up, if you say to your mind they are already covered, so there's no need to provide specifically for them, can you specifically give an example? I mean, if you say they are provided for already, what do you mean by that?
Thank you, Honorable Chair. Now, the Constitution guarantees freedoms and rights. The right to hold property, the right to liberty, so many other rights, except as limited by law. And these are rights that are also enjoyed by intersex people. And I do not see any need for specific legislation in that regard.
My lady, just by way of clarity, it is your case that the Constitution does not place any limitation on such rights as those intersex people are expected to enjoy, correct?
Thank you, Honorable Chair. I do not see any limitation insofar as the rights provided under the Constitution are concerned.
Thank you, my lady. I think we're done with that bit. We'll conclude on the very last part of a set of questions, and I'm going to basically look at Article 21, 1C of the Constitution, which guarantees freedom of religion. And I have specifically framed the questions around the practice and mission-owned schools, particularly Christian and Islamic schools, where students of different faiths are sometimes compelled to attend religious activities that may contradict their own beliefs. Now, if you look at the nature and scope of religious freedom, Article 21C of the Constitution guarantees freedom to practice any religion and to manifest such practice. Now, would compelling a student to attend a religious service contrary to their own faith violate this constitutional provision?
As I look at the provision, it grants the freedoms to practice any religion and to manifest such practice. Insofar as the students are permitted to practice their own religion and manifest the practice, I do not think that there is any infringement.
Yes, my lady, that is understood. That comes without doubt, and there's no ambiguity on that. But my question is, would compelling a student to attend a religious service contrary to their faith violate this constitutional protection? I'll give you an example. I am a Catholic. I attended a Catholic school. But in St. Augustine's, it was mandatory for every student to attend Mass. And my Muslim brothers, my Pentecost, Methodists, SDA were all compelled to attend this compulsory Mass. What I'm asking is, in such a situation, do you see any violation of these constitutionally protected rights?
Thank you, Honorable Chair. I do not.
My lady, why? You are being compelled to practice a faith contrary to your own. My lady may explain to us. We learn in place.
Because rights are not absolute. Every right has its limitation, including being limited by the rights of others and the public interest. So for me, if you are in a Catholic school, having chosen a Catholic school, knowing it is a Catholic school, and you are in a Catholic school, and the code of conduct requires that you do certain things, and you were informed prior to it, and you still chose to attend, then to me it would mean that is not compulsion, because you were made aware, you were informed that when you come to this school, this would be our code of conduct, and you chose to go to the school. So it's not a compulsion, it's a voluntary act, because before you came to the school, you were told that this is a Catholic school, would expect you to go to church on Sundays, would expect you to do this. And you took that voluntary decision to attend the school. And so I do not see that it is compulsion. Yes. Thank you.
My lady, having that in mind, would you say that as part of still ensuring respect for 21C, such institutions should also provide for opportunities to enable other students to practice their faith alongside complying with the specific standard practice?
I believe so. I believe so. I think they should create that opportunity.
Very well. But in creating that opportunity, it doesn't come as of right, or you are anchoring it in terms of guaranteed rights. Is it a matter of discretion or some moral accommodation or something?
It is desirable. It is desirable.
My lady, the concept of desirable, can you expatiate? Some of your law students want to understand you.
It is desirable in the sense that it is a good thing to do. It is a good thing to do, and this is an appropriate thing to do. Yes.
So you will not bring it under the general scope of 21(1)(c)?
Not at all.
Well, fair enough. My lady, in your view, does the fact that a public school owned by a religious mission grants it the right to override constitutional religious freedom of students, in view of what you've said earlier? I just want a clear position.
The situation, Honorable Chair, thank you. The situation is this. The school is not compelling you or insisting that you do anything that you haven't voluntarily agreed to do already by attending the school, because you are told beforehand that this is what we do. You will go to church and you decide to attend the school. So it's a voluntary decision. Now, if you are of the view that it is a compulsion, I believe that there's a forum for that. So the matter can be taken up for the necessary decisions to be taken, and then it will guide us. Yes.
My lady, from what you have said so far on this matter, is it okay for me to come to a conclusion that requiring students to participate in religious gatherings that contradict their beliefs would not amount to any discrimination under Article 17 of the Constitution?
Insofar as I consider it not as a compulsion, I do not see that your freedom to practice your religion is being infringed upon. Thank you.
My lady, let's deal a bit with parental rights and religious autonomy. So many parents have very strong views. Should parents have the right to object when their child is compelled to attend religious activities in schools? And in situations like that, what is the best approach for the courts in handling this? My lady, just to take you and I back to a matter that happened recently, you recall this case where a twin, a boy and a girl, they had admission to Achimota, and Achimota had their own standard. They were Rastafarians, and Achimota required of them to take their Rasta, and they went to the courts to enforce their rights, and the court made some findings against the school and upheld their prayer, and they had to go back. Those were not religious rights, though, but I felt I should tease that out, generally. I mean, in view of your earlier position that once you subject yourself to it, some obstacle appraise against you, you will not now be talking about your fundamental rights, etc., etc. In view of that, do you think that parents who find themselves objecting to such compulsion have any such rights? And if they do, what is the best way for the court to address it by still maintaining some harmony between them and the schools?
Thank you, Honorable Chair. I believe that everybody has a right to proceed to the law courts if they feel that some right of theirs has been infringed. So the courts are available for that. Now, when you go before the court will look at the circumstances of the case and decide whether or not indeed your rights has been infringed upon and whether any remedy should be made available to you. Thank you, Honorable Chair.
My lady, I noticed that you alone, you have two different brands of water, Awake and Belacqua. They give you two. The clerk must be very magnanimous. And we have only Awake with us. My Lord, all three. My Lord, just to let you have some breather, we are done soon. Just 2 or 3, we are done. My lady, the duty of the state in religious neutrality. What constitutional obligations, in your view, does the state owe to ensure that educational institutions, especially those receiving public support, do not infringe on students' religious rights? Emphasis, public support. Maybe a religious or missionary school, but taking state funds.
Thank you, Honorable Chair. I believe that the GES has guidelines and regulations for the schools, and so that would be enforced within the schools. Thank you.
Now, my lady, on the issue of balancing institutional tradition and individual rights, some have argued that religious practice is part of cultural heritage of mission schools. And they are very strong in these views. How should a court balance institutional traditions with the individual's right to religious freedom?
I believe that a necessary determination will be made when the matters are brought to the courts. Thank you.
My lady, this question will be conditional. Conditional in the sense that if you are aware of precedents, if you are not, I'll just move away from it. Are you aware of any case law in Ghana or comparative jurisdictions where the courts have ruled on compelled religious observance in our schools?
I'm not aware.
At all? In Ghana?
I'm not aware.
Zero?
No, I'm not aware.
Okay. My lady, you may want to check. Is that okay? Would you be fine? Since you are not aware, just
I may want, I didn't
check whether there is any such precedence. Your answer is that you are not aware of any precedence at all in our Ghanaian judicial system where we've had the court ruling on compelled religious observance in our schools.
I'm not aware.
You are not. Very well. Well, let me ask you something on faith-based morality and constitutional pluralism. Should a faith-based school be permitted to justify compulsory religious attendance on moral or disciplinary grounds, even if it infringes on the student's religious identity? I'm mindful of your earlier position that was on the fact that the person has chosen to be in a particular environment well aware of certain conditions. But this is looking at a broader scope.
But, Honorable Minority Leader, the nominee has said that GES has their guidelines and rules on this matter.
But, Mr. Chairman, let's end it well. I heard that. The mainstay of this question is whether or not those faith-based schools should be permitted to justify the compulsory religious attendance. She gave an answer in respect of general guidance. But you and I know, Chairman, please, bear with me. You and I know that they've also made several representations to provide justification. I am asking whether or not you hold a view that such justifications, especially on moral or disciplinary grounds, be permitted. I've qualified them. That's why I said these are broader in scope. I've qualified them on moral and disciplinary grounds.
Thank you, Honorable Chair. They are entitled to make their justifications. As to whether or not it is acceptable will be for the regulator to decide.
My lady, you've already told us, and this is my very last question to you. You've already told us that to the extent that a person chooses to be in a school that enforces certain religious rights as opposed to his general rights under 21(1)(c) are impliedly terminated. That being the case, can you share your thoughts on how, in spite of all of these, the judiciary can play a role in protecting students from religious marginalization in public or mission-assisted schools?
Thank you, Honorable Chair. What I said was that the fact that a school has asked that you worship in a certain kind of way does not prevent you from worshiping in your own way. And I was asked whether it was a good thing for opportunity to be granted to them to worship in their own way. And I said yes. So there's no prevention from worshiping in your own way. So it is desirable that you be given the opportunity to worship in your own way. Now, what the judiciary will do will depend on what has been brought before the judiciary. Thank you.
My lady, now, yes, on that set. Now, there are young girls coming from that part of the region where you come from. Many of them placed at the lowest ebb of fortune's wheel. They are watching you. They have seen you rise on the social ladder. Today, I'm sure some of them may shape their opinion, seeing a woman being elevated to the Supreme Court of our country. You have earned it through your own patience and industry. You've risen to eminence by merits, and I'm sure you are respected among your equals. Can you share your thoughts on your journey to this high pedestal with that girl child out there, and say a word or two to inspire them that nothing is impossible? And that will be all for you, my lady.
Thank you very much, Honorable Chair. I would like to tell the girl child, as I have been asked, that with hard work, perseverance, and God on your side, you can reach the heights that you dream of, and nothing is impossible unto God. So they should continue to work hard with determination and integrity, and they would reach the heights and even beyond what I have reached. Thank you.
You can say that in your local language to them, because I want you to address your locals. Is that okay? Maybe you said it in English, if in brief, just to.
Minority Leader, the rules are very clear. It is only when you say something in a local language that the rules enjoin you to translate it in English. In this case, having said everything in English, there is no rules that allow you to then translate the English into a local language. So please, you are not permitted to do that. We've come to the end of your vetting. I will give the floor to my Vice Chairman to do the needful.
Thank you very much, Chairman. As you rightly said, we've come to the end of the vetting. The nominee came with friends, family, and colleagues, and we would like to acknowledge them. First on my list is Mr. Amaliboba Esquire, who I believe is a spouse. Mr. Abdul Latif Isifu, Mr. Suleimana Osman Saka, Kompini Na Bukari Yahaya, Mompeni na Alaji Said Isa, Mr. Fauzi Isifu, Ms. Faida Isifu, Dr. Nicholas Atambugri, Madam Gloria Owusu Afram, Dr. Erica Ntiamwa Mensah, Professor Samuel Atinton, Dr. Andrew Akola, Colonel S. Babila, retired, Mrs. Juliet Babila, Mr. Wahid Pampori Idrisu, Esquire, Mr. Philip Jimano, Esquire, Justice Christopher Archer, Justice Samuel Obin Diawu, Mr. Andrew Stete, Esquire, Alaye Cyprian Yusuf Anwari Nabali, and we have the Acting Chief Justice with us and other justices. So that's the end of the friends, family, and colleagues who are here to support the nominee, and we acknowledge them. Thank you very much for coming. I hand over to Mr. Chairman. Thank you.
Honorable members, As indicated, we've come to the end of the vetting. We thank the nominee for attending upon the committee and answering questions. You would hear from the committee, and you are hereby accordingly discharged.
Thank you, Honorable Chair.
Is your trusted partner, providing seamless solutions for all your procurement needs. From sourcing products to managing imports and exports, we ensure smooth and efficient transactions every step of the way. Whether you require goods from across the globe or need assistance in exporting your products to international markets, we got you covered. General trading is at the heart of our expertise. We specialize in a wide range of products, catering to various industries and markets. As a trusted dealership in building materials, we provide high-quality products that meet the demands of our construction projects. Additionally, we act as manufacturers' representatives, connecting producers with distributors. Our expertise in logistics is the backbone of our operations. We plan and execute transportation